Yo, what's up, man? Follow me on all the platforms: TikTok, Instagram, Facebook, Spotify, the podcast of Soul. There is a rule in the federal system, Rule 3553. And Rule 3553 has to deal with the sentencing of a defendant at the sentencing hearing. It has to do with the sentencing guidelines. Now, there's a section in Rule 3553. The section is 3553, Section A, subsection 6. And in that section, it talks about sentencing disparities. Because in the sentencing guidelines, when you're getting sentenced in federal court for a criminal case, your sentence goes by the sentencing guideline range, the sentencing guideline table, which is this thing here. This is the sentencing guideline table. Whatever your conviction is, it will register, it will receive a base offense level, which probation will assign you based on your PSI. It'll fall somewhere within this base offense level, and you look based on your criminal history points, and that's how you arrive at your sentence. The guideline range. Now, the judge has discretion to do an upward departure or a downward departure at his discretion based on your criminal history and the nature of the charges. Now, what Rule 3553, Section A, subsection 6 does is that it says to the court, to the judge, that you need to look at other cases similar to the case that you need to look at other sentences and cases similar to the case and the sentence that you feel you are going to render in the case before you. And what you don't want is sentencing disparities. That's good. What I mean, Sean, what do you mean by sentencing disparities? Sentencing disparities is you stole a pack of gum and you ran out the store. You got busted, you got caught, you got sentenced to a year in prison. This person, 7 months later, does the identical thing, steals a pack of gum, runs out of the store. But same criminal history, same dynamics, same everything. But the judge gives this person 4 years in prison, 4 times the time that the other person got for the exact same offense. That is a sentencing disparity. Now, this is what happened in Puffy's case. And this came up at the sentencing hearing. This was brought up by Jason Driscoll. Now, this is on page 53 of the 156-page sentencing document, right? Page 53, line number 18. This is Jason Driscoll talking to the judge. Because what was real clear in Puffy's case was that I don't know if ever but it was definitely hard to find, or if ever it even existed, where there was a case where the prostitutes, the so-called quote-unquote prostitutes, were men. Most of the times when you're talking about a prostitution case, you're talking about women or girls. That wasn't the case in Puffy's case. Line 18. I'm going to talk about sentencing disparities, which is section 3553, section A, subsection 6. And just taking a step back for a moment, Your Honor ruled on the guidelines range. And what 3553A teaches us is that the guideline range is just one factor. There's a separate section, section A, subsection 6, that counsels the court that the court must also fashion a sentence recognizing the need to avoid unwarranted sentencing disparities. Why? The guidelines were designed to create uniform federal sentencing practices. So why do we need section A, subsection 6? And the recognition there is that a technical, mechanical, blind reliance on the guidelines can actually create disparity. And respectfully, Your Honor, if you applied the guidelines range that you find today in this case, that would exacerbate serious disparities in the federal Mann Act sentences. So what Jason just said was, the judge initially the judge on July the 9th, 2025, asked the prosecution and the defense to come back with this guideline range. Okay? 18 USC 2421, 2G1.1, section A, subsection 2. That guideline range for that order put forth by the Ivy League judge in Puffy's case brings back a sentencing guideline range of 14, 15 to 21 months based on a criminal history of 1 or 0. So this is the guideline range that he initially told both sides to deal with. However, at the sentencing, he enhanced Puffy's guideline range 13 levels to a 27. 70 to 87 months. He said it out of his mouth in the sentencing hearing that Puffy's guideline range was a 27. He got increased, Puffy got enhanced 13 levels as a first offender in a Mann Act case, which is unheard of. And what Jason is saying is that, and he told them, if you apply that guideline range to Puffy's case, you will in effect be engaging in sentencing disparity with Puff, meaning over sentencing him. This is a case point, page 54, Jason Driscoll. For 75 years, long before Sean Combs was even born, the Department of Justice has said, as a general rule, prosecution of Mann Act cases should not be instituted in the so-called non-commercial cases. The Department of Justice recognized commercial gain as a serious aggravating factor. And the government, the Southern District of New York, does not dispute today that Puffy did not make a single cent off of his Mann Act conduct. That aggravating factor of commercial gain is completely off the table. Now, that brings me to the Jordan case that the Ivy League prosecutors, the Southern District of New York, the losers, just cited. Respectfully, the Jordan case is not comparable to Puffy's case at all in any way. The Southern District of New York, Christy Slavic, who went to the University of Penn Law School, Ivy League Law School, cited the Jordan case and the another case, Mi Sun Cho. But Christy Slavic, the assistant U.S. attorney of Ivy League pedigree, cited this case, the Jordan case, as very similar to Puffy's, and that Puffy's sentence should be meted out because his case closely resembles the Jordan case. Now, we already know the Puffy case, the details. Let's check out the Jordan case. Now, that brings me to the Jordan case that the government just cited. Respectfully, in Jordan, the defendant received a 60-month sentence. Puffy got 50 months. That's a 10-month difference. That's very, very similar, very close. As Your Honor just noted, Jordan served 8 years in a Cuban prison for sex crimes prior to committing that offense. So he had already had a first offense for the same charge. In other words, that was his second chance. He got out of jail, he did it again. But his offense conduct looks nothing like Sean Combs. That defendant, Jordan, ran an international prostitution ring over a span of 7 years. He recruited dozens of young, vulnerable women to be prostitutes. He had over 100 clients. He made $1.4 million. Do you know how many commercial sex acts you need to sell? How much abuse, how much suffering women have to go through for you to make $1.4 million off of Mann Act conspiracy violations? Puffy's offense is nothing like that. Jordan's case was worse in other ways. 3 of the victims reported unwanted sexual advances and other forms of traumatization. One of the victims there was actually assaulted, RAPED, by the defendant after being drugged. Notably, Your Honor, back to my initial point about overly technical application of the guidelines, the government, the Southern District of New York, didn't even seek the fraud or coercion enhancement in that case. This office, the Southern District of New York, didn't even seek the fraud or coercion enhancement based on my reading of that case, and it was not applied by the judge. So, look at the sentencing disparity. This dude got 60 months, which is the same as 50 months. 10 months in the federal system it's the same. It's within the same year. He made $1.4 million, had over 100 clients, dozens of women and girls, drugged some of his victims, took the kitty cat of some after he drugged them. Totally different dynamic. This guy's behavior was way worse than Puffy's, yet they got almost the same amount of time. So this is the sentencing disparity that Jason Driscoll is talking about in 3553, Section A, subsection 6. Here's another case. The Ivy League prosecutor, Slavic, who lost the trial. Slavic was the assistant U.S. attorney that gave the closing argument for the prosecution that lost the trial for the Southern District of New York. Because after Mark Agnifilo came after her and showed the world how to really do a closing argument, the jury rejected Christy Slavic's closing argument. It rejected the Southern District of New York's prosecution of Puff. It rejected the 34 witnesses. It rejected the racketeering conspiracy. It rejected the sex trafficking charge. It rejected everything the Southern District of New York had to say about the RICO and the SEX trafficking, and it acquitted Puff. The government, the Southern District of New York, also mentions the Mi Sun Cho case. This is Jason Driscoll, page 55. And respectfully, again, that case is nothing like Puffy's case. Mi Sun Cho was an international prostitute broker of sorts. She had connections to brothels and other sex trafficking rings. And she too profited from the offense. Worse, this was her fourth time dealing with the criminal justice system. I believe she had 3 prior instances of arrests for prostitution, one of which resulted in a suspended 1-year sentence. Again, a court gave her, in that case, a 4th chance, and she blew it, and she got 60 months. Puffy got 50 months. This lady got 60 months. This was her 4th offense, meaning that her criminal history category, Puffy was here, would have won. Hers would have been over here, 2, 3, or 4, based upon the time in between the different convictions. So, this case, Puffy's sentence, he was over-sentenced. There is a major sentencing disparity in the sentence of other defendants in the Southern District of New York who had far worse conduct than Puff, were for-profit commercial prostitution rings, and Puffy had none of that, yet they almost got the same time. Sean G, Podcast with Soul. Peace.